Hi, Joy. Thank you for joining us.
It's a pleasure to be here.
Great. Let's start by getting to know you better. Tell us a little bit about yourself.
I think I've mentioned to you before, Jem, I started in the space quite a while ago. So it was 5-6 years ago. And it was really the kind of Zappo initiative at the time. They were looking to build out an electronic money license framework for the fiat element of their Bitcoin wallet. And lots of conversations with them, mostly with Wences Casares. He said to us, look, Gibraltar, small jurisdictions, you have a competitive advantage. You are able to adapt to new things much faster than larger entities, like larger institutions, I suppose. And he encouraged us to approach the government at the time with the concept of building out a purpose-built, ground-up regulatory framework for the use of distributed ledger technology. At the time, it was mainly sort of crypto focused, but it evolved quite a bit. So we started that process a long time ago, and that law came into effect a few years ago. My background is in financial services, etc. But as I spent more and more time, I'm now almost 100% dedicated to the law and regulation in this space. And because we were effectively, to an extent, pioneers. We were the first jurisdiction to introduce this. It's generated a lot of interest from lots of other countries. So, and that's one of the reasons I'm involved in so many different initiatives around the world to sort of share some of our experience, which has been a very steep learning curve, but a wonderful development as well.
Yes. And for businesses to succeed, I think it's really important to have legal certainty. And I know that Gibraltar has been paving its way for developing a principle-based regulatory framework.
Yeah.
And I know you've been very involved in that process.
Yeah.
So could you tell us a little bit about that as well?
Yeah, it's interesting for lots of different people to hear in different jurisdictions. So the reason that we approach this from a principles perspective was, so we looked at what had happened in the world. We looked at things like the BIT license in New York, super codified and detailed, hundreds of pages of legislation. We looked at existing financial services law and its development and over many hundreds of years, etc. And we took the view that because this industry is so fast moving and so fast evolving, it would be very difficult to codify a detailed set of rules that would be adequate, real, and appropriate in even 6 months. So the way that we approached it was to define what we feel are sort of core principles relating to a well-run business. And they relate to, very specific things relating to this industry. So in respect of its custody arrangements, in respect of its security arrangements, in respect of its capital arrangements, in respect of its governance structure, et cetera, et cetera. But accompanying those principles, we have much more detailed guidelines. So the interpretation of that principle is in more detailed guidelines, and those guidelines, because they don't form part of the law, can be emerged and adapted and amended very, very quickly. So that was the way that we felt it was most appropriate to try to keep track of developments and keep emerging and changing those guidelines to adapt to those principles. That was what we thought was the most appropriate way of approaching it. And you're absolutely right. Why would people set up their operations in Gibraltar? It's absolutely a question of legal certainty, regulatory certainty, tax certainty. These are very, very key principles, which in the old world are taken for granted. In the new world, they're high risk. There are many jurisdictions where it's not really clear of whether you fall within the scope of some existing law or outside of the scope, and no one wants to operate within a grey area. It's insecure for the business, and it's even more insecure for the customers that business is serving. So we've, I think, had a lot of success, and the standards are very high. That's another very important thing, because I've seen some jurisdictions introduce what I would say are very base layer registration requirements, very, very simple. And that, to me, is honest. And we've learned from that in the past. There have been jurisdictions that have tried to do that, tried to open the doors very, very wide. The way that we've approached this is to set the bar extremely high. And because we're a small jurisdiction, we're not interested in running 500 exchanges from a small jurisdiction. We want to be selective. We want to set the bar very high and attract the right groups and build the right community around that. So that is what has driven the whole initiative, and it's been a lot of work.
Great. And speaking of other jurisdictions, how would you distinguish Gibraltar from other jurisdictions such as Hong Kong or Singapore?
I mean, for me, it's very, it's different. I mean, I've got lots of good things to say about what the MAS and what the teams are doing in Hong Kong. You know, I suppose one example in Singapore might be that, you know, following the recent, you know, FATF guidelines and everything else, they've encouraged this risk-based. The FATF have encouraged this risk-based approach to regulation and registration. You know, they've also defined the sort of threshold limits from an AML compliance perspective at 1,000 euros or dollars, occasional transaction limits. You know, Singapore have approached that at 0. So, you know, $1 triggers a requirement. So they're very conservative from that perspective. Others are, you know, feel that 1,000 euros is way too low. But then the flip side of that is that most of the larger jurisdictions, and I would put Singapore and Hong Kong in those senses, it's very difficult for them. They sit on existing large infrastructure and large business. It's very difficult for them to build out entirely new frameworks for a new and emerging area. The big organizations, big regulatory authorities. So what I've seen is, I would say that Singapore, the more active, they've amended their Payment Services Act or Bill, which has passed and comes into effect on the 1st of January. And it will specifically capture lots of activity in the space. It will definitely capture exchange-related activity, but then it would not cover, from what I understand, you know, custody-related activity, which is also one of the FATF recommendations. So I think they are probably already looking at trying to evolve their law before it's even come into effect. They're probably looking to try to do that. But it's different to, I suppose, Hong Kong, where, again, I think they've just tried to place these new services and new facilities or business types definitely within old existing law. So if you operate, from what I understand, under an existing license in Hong Kong, you're able to add certain activity relating to crypto-related business, but you're not able to apply for that license if you're just a crypto-related business, which is slightly odd, because that would also lead to groups trying to apply for licenses that doesn't really cover the activity that they're conducting, just to tick the box to be able to facilitate the business that they're actually doing. It wouldn't make sense for me, in ultra simplistic terms, to obtain a brokerage license for one equity and actually conduct, you know, a crypto OTC business. It doesn't really make sense. But at least it's emerging in both jurisdictions, in both Hong Kong and Singapore. I think there are lots of smart people, lots of big community of users, but moving regulatory authorities and government institutions just takes longer. I mean, it just takes longer. And that's small. You know, those are the big jurisdictions, but relatively speaking, when you start talking about the US or other larger, that's even harder. So, and I suppose you would put us at the diametric opposite of that, where it's much easier. We feel in smaller jurisdictions, I think we feel we have to evolve. We have to adapt to new things. If London or New York or Singapore or Hong Kong say let's sit on our existing business and facilitate the activity that we have, there's no problem. But in smaller jurisdictions, unless you're evolving, in my view, you know, if you were to sit on what we had for 15 years, it would be the end of the game. You have to keep evolving to keep up with development. So that's kind of what we're doing.
Good. I guess it's really interesting for me to hear, because I think you are in a very unique position, having been involved with the regulatory side, but also, you know, having your own private practice. So from the regulator's perspective, how do you balance nurturing entrepreneurship, but also, you know, dealing with some of the risks that are involved? So what advice and how would you strike a nice balance between the two?
That's a difficult one. I mean, I think in some jurisdictions they've approached it from a kind of, let's call it, sandbox perspective, and that is their facilitator, or call it incubator, for allowing businesses to operate. And normally it might be to certain restrictions or certain levels or certain transaction volume limits or certain number of client limits. So it's a kind of testing environment, and that is generally seen as quite positive. Even more positive than that, for some people, would say, let's develop, you know, not even a sandbox, just self-regulated or groups or authorities or standards where the industry itself, and if the regulator accommodates that, effectively you're allowing a new type of business to incubate itself and the environment and the platform and everything else within rules that are set by the industry itself. From my point of view, though, you know, self-regulated bodies, organizations, it's great that they can work to define principles. There's no enforcement powers from a self-regulatory authority. So you're operating to standards. If you're operating to those standards, that's great. If you're not, who does anything against you? And with the sandbox, I think that it's great when some jurisdictions do that, and that they're accommodating things. But at the same time, maybe it's too pessimistic, but they're also, you know, sandbox is a kind of restrictor. You're not really validating the business. You're not licensing the business. You're not putting it on an even keel with other existing financial services businesses. So it's good that it's facilitated, but at the same time, it's kind of restricting it. It's kind of closing it out. So the really difficult piece for a startup or that kind of thinking is to find places that will actually validate what you're doing, actually license what you're doing, recognize what you're doing, which gives a massive amount of comfort to banking service providers, other more institutional related groups, insurance providers, audit providers. If you're a regulated business that you're licensed, it's just different. But finding the right framework to license and protect consumers within an operating model that also accommodates and allows for a kind of incubator style startup, that's very difficult. That is very difficult. So we have our own approaches to that, and everyone has slightly different approaches to that. But I would be encouraging people to find the right model that fits for them, and definitely not to try and avoid it. I mean, the groups that you know, there are groups that set up in, you know, whatever, some jurisdiction somewhere in the world, some island or whatever it is, because they feel that they're allowed to do whatever they want. And that to me, it's such an obvious danger signal. I can't believe that serious people would think about doing that today. So, but targeting the base and setting the foundation layers on day one is super important. Trying to transition from a bad environment to a new good environment is extremely, extremely difficult. So setting the foundation, taking those difficult decisions, you know, investing yourself, having the right backers, like Hash, I mean, it's a hugely significant part of what these groups can do. I would say those are fundamental for all of these guys. So.
And I think a crucial element of that is being educated and being able to share some of the knowledge. And I know that you've traveled the world to talk with regulators, and I know, for instance, you are very much involved with the UNDOC, the Wharton RegTech initiative.
Yeah.
How would you summarize some of the global regulatory landscape at the moment?
I would say it's dramatically different. It's really dramatically different when jurisdiction by jurisdiction. So sometimes or some people or some idealists always say, oh, there should be a global standard for regulation and control or token categorizations. I mean, that for me is just a complete pipe dream. I mean, in some jurisdictions, like in Thailand, they have recategorized different kinds of tokens to put them within separate brackets. But most interestingly, as opposed to say Switzerland, which has a kind of utility versus payment versus security categorization, they've introduced in Thailand the concept of an investment token. So an investment token that has traits of a security, but doesn't categorize itself as a security, but it has a separate class and it's recognized in a separate way. And they've built a lot of things around that, which are actually very interesting. But the reason I'm saying that is try and get 50 other regulators to acknowledge that an investment token as a try and get the US or the SEC to recognize a new class of non-security investment-like I don't think that can happen. In other jurisdictions, like in suppose in Australia, Austrac, etc., they've introduced a license or a registration regime, and I think they look at certain things. They look at the people that are involved. They look at the company, etc. But they don't go really beyond that. They don't go to the more complex. It's my understanding. So the actual infrastructure of that business. The requirements are very simple. So they're encouraging the environment to grow. They've had 250 groups or exchanges regulated or licensed or registered in about a year, and that could potentially open many other danger signals. In South America, it's very different. I think there's less of a focus in some jurisdictions like Mexico. There are big communities looking to evolve the law. There's a transition phase now, or a sort of fintech law transition period that they're in at the moment. But again, some of the bigger groups in Mexico that we work with, have started their operations. Bitso is one of those, the largest exchange in Latin America. We've done that in consultation with the regulator in Mexico, etc. Because they don't want to regulate that business, and we provide a safe environment to actually control that, and that should also provide comfort to the Mexican regulators. But everywhere is sort of, and there are some jurisdictions where, to be honest, I won't name them, but that they don't really understand. I would say they haven't yet come to really understand what this means. I think historically there's been a very obvious AML focus. Everything's been around AML and compliance, starting back with, I suppose in 2013 with FinCEN in the US, where they recategorized virtual assets as effectively as a currency and brought them within the scope of their money service business rules, etc. But that was very AML focused, and in lots of jurisdictions, I think the focus is still on that, which, in my experience dealing with some of the businesses that I've dealt with, and I just think that's it's just too simple. Initially, the focus was all around money laundering, but if this is really going to grow into something more serious, you have to look at those arrangements. If Quadriga is hacked with hundreds of millions of BTC stolen, etc., it does not matter what the AML processes were. And that they could recognize everyone who lost their money. They had no custody arrangements, they had no security arrangements in place, they had no insurance cover, they had nothing in place, and which led to a significant loss. That could not happen to a properly regulated and controlled business. So I would hope that, I think all regulators are at a starting point. All of them have seen the FATF recommendations. All of them have seen the VASP categorization with some of its, and now it's up to them to see how they're going to approach that. But I often say to countries or to regulators, I mean, you cannot do nothing. I mean, you cannot sit on the back fence as some of them were doing a year ago. So it will continue to evolve. It will be a very interesting next 12 months.
Yeah. And I think you're right to point out the FATF, because that's the big conversation in the industry for the virtual assets and virtual assets providers, service providers. And maybe given your industry knowledge, maybe you are able to quickly anticipate some of the shortfalls. And I think one of them being mostly debated issue around the travel rule.
Yeah.
Would you be able to comment on that?
Yeah, I mean, generally speaking, very high level. I would say, I mean, outside of the travel rule, just the categorization of a virtual asset service provider. So to give you one simple example, in Europe, the European Union has developed its fifth anti-money laundering directive, comes into place in March, and covers certain services. So certainly custody-related activities would be covered. Certainly exchange-related activities where there was a fiat touch point would be covered. That there are many inconsistencies already between the fifth anti-money laundering directive, which hasn't yet come into place, and the definition of a virtual asset service provider. So already the sort of, it's a strange sort of situation where the union is moving in one direction to categorize things, and it's kind of already out of date with the definition of what FATF have defined as a virtual asset service provider, and other jurisdictions have defined that in different ways. And there are a lot of interpretation issues about what a virtual asset service provider actually means. So that is one sort of discussion point, if you like, and that will be for each jurisdiction to interpret the recommendations, etc., unless there's even more guidance that's offered. But yeah, the really contentious one is the travel rule, and for those who aren't fully aware, I mean, I'm only saying it because not everyone is even fully aware that recommendation 16 is there. But there's if you are onboarding a customer and you're a wallet provider, exchange, or whatever it might be, you're going to always have an obligation to identify who that person is. That's always been there within any base form of regulation or onboarding. But the travel rule introduces an obligation for a transfer from a virtual asset service provider, so the originator, to identify the beneficiary. Now that copies the SWIFT payment system on the banking network and Rails, which is completely normal, although the SWIFT system has been subject to all sorts of abuse in the past, but it's encoding that sort of theory or principle within the crypto space. Now, that is very difficult so if you're transferring from an originator to a beneficiary, I mean, the first point is the transfer to another VASP is what triggers a requirement for you to identify who that beneficiary is. How do you even identify that the wallet that the transfer is being made to is itself linked to a virtual asset service provider, and it's not some offline ledger wallet, whatever it might be, someone's individual personal offline? That's just a base starting point. The other more complex point is, even if you're able to identify who that the wallet is linked to a virtual asset service provider and the travel rule recommendations are triggered, how do you actually do that? How are you going to encode someone's personal data to a transaction? Are you going to encode it on the actual chain? Is it a side chain that attaches to that transaction? I mean, there are many different ways. There are all sorts of issues around that. I mean, one of the most basic ones is in relation to GDPR and data privacy related things. If you're locking someone's identity to a transaction on an immutable ledger that sits there forever, that's a huge, well, that doesn't work. Yeah. So how do you do that in a safe and sufficient way? And again, in the travel rule, we formed our own working group with very, very specialist providers, and it's relatively it's definitely closed, because I feel that we have to have representation from the compliance industry, from the analytics industry, from the industry, from the actual providers, and really, and obviously the legal input as well. Lawyers are very important, but that works in a certain way. And the reason that done that is that there are so many different big groups that have been formed, and again, some of it's very, it's lovely, but it's very idealistic. That there's going to be some centralized non-profit organization where every virtual asset service provider in the world will register and centralize its data and information, and all of the wallet addresses and everyone's personal data will be controlled by this non-profit entity. I mean, I just, and people will say, well, that's how Swift started, and I just cannot see that happening. So there's no short-term immediate answer to the travel rule, but there are lots of working solutions and lots of people approaching this in slightly different ways. The way that we're approaching it is we already regulate virtual asset service providers. We already have that law. We've already been doing that for 2 years. There's nothing new for us. The travel rule is something new for us, but we already have the part of the regulation of VASP. So we're adding that facility through a very specialized service that we want to be able to offer to regulated virtual asset service providers, at least in Gibraltar. And if we see that working, then it will be something that, of course, we'll be discussing and opening to the rest of the world. So,
great.
Yeah.
So I would like to end this interview by doing our signature move at Hashed, which is, our brand.
Yeah.
So could we do that as a
sure.
goodbye to our audience together?
Absolutely.
Great. 3, 2, 1. Hashed. Thank you. Cheers.
Thanks, Sid. Yeah, that was good.